and welcome to my video. Let's start this video with a saying from the High Court of Bombay, which is, marriages are not made in heaven, they are made in hell. Well, the comment was made by the court when they granted a pre-arrest bail to the man regarding domestic violence and dowry case filed by the wife in Mumbai. This is Jerry, your host, and today we are diving into the topic that's both sensitive and crucial. The top 10 things you should know before filing for a divorce in India. So, if you or someone you know is planning to take this drastic step, then please stay tuned. Divorce can be tough, both emotionally and legally. It's not about ending a marriage. It involves a lot of feelings and complex legal steps. But don't worry, understanding the key points can make this process a lot easier to handle. So let's discuss the top 10 things you should know before filing for divorce in India. This will help you to be better prepared and make things a bit smoother. So let's get on with the video. Well, in this video, you will learn the following. First, what are the different types of divorce in India? Second, what are the grounds for divorce? Third, jurisdiction in which can the divorce petition be filed? Fourth is about maintenance and alimony. And fifth is about child custody. Sixth is about property division. Seventh is what is called cooling off period. Eighth is alternate dispute resolution. Ninth, who should represent me in the case of divorce? The 10th question is the impact of divorce on a person's future. In fact, for each issue, I have researched a case law which I hope might be useful for you in case you or the person whom you know is planning to take the extra step of parting ways. So let's shorten this talk and get into the important part of this video fast. The first question is, what are the different types of divorce in India? In India, there are two main types of divorce. One is mutual consent divorce and second is contested divorce. Let's talk of the former, which is the mutual consent divorce. Here, both spouses agree to the divorce, and this is governed by section 13B of the Hindu Marriage Act of 1955. Let me start this with a case law, which is Sureshta Devi versus Om Prakash. This case was in 1991. In this important case, the Supreme Court made it clear that both spouses must agree to the divorce, not just when they first file the case, but also when the final decision is made. Let's move on to the latter part of the divorce, which is the contested divorce. One spouse files for the divorce without the other person's consent or the other spouse's consent. Grounds for divorce include cruelty, desertion, adultery, etc. The appropriate case law for this sort of divorce is Navin Kohli versus Neelu Kohli. This was in 2006. The court held that sometimes a marriage can break down completely, with no chance of getting back together. Although there is no official reason for divorce as per the law, this case has shown why it is a reason for a couple to seek divorce from the court. Well, the second question is, what are the grounds for divorce? Different personal laws govern different communities. Personal laws are the laws by which an individual is governed in respect of various matters such as marriage, divorce, and maintenance. However, below are some common grounds as per those personal laws. Under Hindu law or Hindu Marriage Act of 1955, divorce can be granted for cruelty, adultery, desertion, conversion, etc. Let's go to Muslim law. Under the Muslim law, divorce can be granted for talaq, pronounced divorce, or kula, divorce initiated by the wife, etc. Under the Christian law, Indian Divorce Act of 1869, it allows that divorce can be granted for adultery, conversion, cruelty, etc. The case law for grounds for divorce is Samar Ghosh versus Jaya Ghosh. It was in 2007. In this case, the court talked about mental cruelty in marriages. They said that mental cruelty is different for everyone and can't be strictly defined. The main things to look for is the behavior aspects, that the couple's mental health and the ability to live together. The third question is, in which jurisdiction can divorce case be filed? It is crucial to file for divorce in the appropriate jurisdictions. Typically, it is where the marriage took place, or where the couple last lived together, or where the respondent currently resides. In the case of Anindita Das versus Srijit Das in 2006, the Supreme Court held that it is important to file a divorce in the correct jurisdiction. According to the court, a divorce petition can be filed where the marriage was solemnized, or where the couples last resided together, or where the respondent currently resides. Filing in the wrong court can lead to significant delays and complications. Also, this shows the need to choose the appropriate jurisdiction. The fourth question is about maintenance and alimony. The court may grant maintenance or financial support to the spouse who cannot support themselves. An apt case law for this is Daniel Latifi versus the Union of India. It was in 2001 this judgment was passed. The Supreme Court upheld that Muslim women are entitled to receive fair and reasonable financial support after divorce. This decision actually reinforced the right to maintenance, ensuring they were adequately taken care of. The fifth question is about child custody. A child custody is determined based on the interest of the child. The court may grant sole custody to one parent or joint custody to both. It was held in the case of Gaurav Nagpal versus Sumedha Nagpal. This judgment was passed in 2009. The Supreme Court affirmed the principle that the welfare of the child is of utmost importance in custody decisions. This means that the court's primary concern when determining custody arrangements is the well-being and the best interest of the child involved. The case highlighted that it is the court's responsibility to prioritize the emotional, physical and psychological needs of the child above all before deciding with whom the child has to be looked after. Now the sixth question is about property division. In India, when it comes to dividing property during a divorce, properties cannot be split equally. Instead, it is based on who owns what and who has contributed what during the marriage. So, if one spouse bought a house before they got married, that house might be considered their separate property. But if they bought it together during the marriage, then it is shared. Let's discuss the case law, which is Pratibha Rani versus Suraj Kumar, whose judgment was passed in 1985. Before we discuss this case, let's discuss something what is called as Sridhan. So Sridhan is like a personal property that a woman brings when she is getting married, like jewelry, clothes, gifts, etc. In the case of Pratibha Rani versus Suraj Kumar, the court said that the wife has a right to her Stridhan, meaning her personal belongings, even if the marriage ends. Plus, they also said that the husband has to provide maintenance to the wife, which means he has to help support her financially, even if she doesn't have enough money to support herself. So, this case made it clear that women have rights to their Stridhan and deserve financial support even after divorce. The seventh question is, what is called the cooling off period? For mutual consent divorce, there is a mandatory cooling off period of 6 months after filing the case. However, this can be waived under certain circumstances. There is a case law for this. In the case Amardeep Singh versus Harbeen Kaur in 2017, the Supreme Court allowed the waiver of 6 months cooling off period, fast forwarding the process of mutual consent divorce. Now the eighth question is about alternative dispute resolution, or let's call it ADR in short. Before going to the court, it would be recommended that ADR methods like mediation or counseling can be tried. This can save time, money and emotional stress. Let's discuss a case law on this. It's called K. Srinivas Rao versus D.A. Deepa. In 2013, the Supreme Court suggested using mediation to sort problems out between married couples in a friendly way. So, instead of going straight to court, they encourage couples to try talking things out with the help of a mediator, someone who can help them find a common ground and come to an agreement without all the stress and conflict of a courtroom. The ninth question is, who should represent a spouse in the case? Well, having a competent lawyer can make a significant difference. They can guide you through the complexities and ensure your interests are protected. It's the best to find a lawyer who knows about family law and has dealt with divorce cases before. They can give you the right advice and help you through the whole process, making sure your rights and interests are looked after. The 10th question is about the impact of divorce on a person's future. To understand the long-term implications, we have to consider other factors which include social, financial and psychological aspects. Divorce is not a legal termination of marriage, but also a significant life change. I feel it is crucial to seek support from your family, friends or professional counselors to cope with the emotional loss. So I have explained the top 10 things you should know before filing for divorce in India. Remember, this video is only a general overview. Every case is unique, so it is essential to get personal legal advice from a lawyer who specializes in family cases, as I have told you before. If you found this video really helpful, please hit the like button, share it with others who might benefit, and leave your questions in the comment section below. Don't forget to subscribe to my channel for more legal insights. Thank you for watching and see you in the next video. Take care and bye-bye.